And I have made specific proposals going back to the time when I was a practicing attorney and Chief Justice Ed Pittman was in office, and I made these publicly, actually on Mississippi Public Television, for a blind system of contributions, so nobody would know who gave to whom in judicial races, and the justices and the judges would not be operating under any sort of cloud of favoritism. I have never looked at my campaign finance reports. I've never looked at Judge Griffiths or my former opponent in the last race. As far as systemic changes in the system, most of those have to come from the legislature. The Supreme Court might be able to appoint some sort of commission to study things and maybe make recommendations to the legislature, but we have to keep in mind that we are a separate branch of government. And we have to be very careful not to tread upon legislative prerogatives. And our court, I think, is very scrupulous in that regard. The Lester Brown case that was mentioned, I wrote a stinging condemnation of the way that man was confined in jail from 6 years after his trial until finally somebody realized he was over there and he was granted an out-of-time appeal by a judge up in Coahoma County. You know, the Supreme Court really doesn't have much way to monitor things like that. That's local stuff, and I'm not passing the buck to anybody, but I think it's unrealistic to think the Supreme Court can have much impact on that, except in the strict adherence to, and you asked a very astute question about speedy trial issues. Those are constitutional issues. And in addition to that, we have had a statute on the books in Mississippi for many decades that the court, without my assistance, has carved out many exceptions to, and that's called the 270-day rule, which provides that from the time a person is arraigned on a felony charge until he or she is tried, and that case is disposed of, that must be done within 270 days, 9 months. But we have countless cases that have come to our court where we found ways around that. And I have advocated and will continue, if I'm on the court, to advocate to strict adherence to constitutional safeguards about speedy trial and everything else. I think that makes me the conservative. When I want to conserve the criminal rights of accused persons that are found in the Mississippi Constitution and in the U.S. Constitution. And again, I say if they don't work for everybody, we can't expect them to work for anybody.